Two teenage girls tell police that the same boy raped them, strangled them, and learned how to use fear to keep them from resisting. He is charged with 11 felonies. If convicted and sentenced as an adult, he could face decades in prison. Instead, he receives counselling, community service, a curfew, and no time behind bars. Then, before one victim can fully challenge the deal, his supervision ends. The case is closed, and Oklahoma cannot prosecute him again. Tonight, we're examining the Jesse Butler case, the youthful offender agreement that enraged a community, and the uncomfortable question it left behind. When does rehabilitation become mercy? And when does mercy begin to look like injustice? Welcome to the podcast, You Can't Unhear. Before we continue, Jesse Butler entered pleas of no contest. That means he accepted the court's punishment without formally admitting the allegations were true. Legally, a no contest plea can still support conviction and sentencing. But it is not the same as standing in court and saying, "I did this." The descriptions of the assaults come from police affidavits, victim statements, and evidence referenced during court proceedings. The case began in Stillwater, Oklahoma, with allegations from two teenage girls who had separately dated Butler. All three teenagers were 16 or 17 when the alleged conduct occurred. The girls did not describe a single misunderstanding or one incident after a relationship ended. They described repeated sexual and physical violence. One girl said Butler ignored her when she said no, held her down, and told her he was sorry for what he was about to do, but that he had to do it. She described another encounter in which she tried to leave, and Butler allegedly pulled her back, telling her she was not going anywhere until he was finished. The second girl said she learned to alter her own behavior to avoid provoking him. She alleged that he pinned her down, strangled her, and found her panic amusing. Police documents described strangulation severe enough to cause unconsciousness. In March 2025, authorities arrested Butler. He was 17. Prosecutors initially filed the case in adult court. The 11 counts included attempted first-degree rape, rape by instrumentation, sexual battery, forcible oral sodomy, domestic assault and battery by strangulation, domestic assault and battery, and violation of a protective order. The potential adult sentences added up to approximately 78 years. The large number did not mean Butler would automatically receive 78 years. Sentences can run concurrently, charges may merge, and judges retain discretion. But the filing made one thing clear. The state initially treated the allegations as extremely serious adult crimes. Then the direction of the case changed. Butler's lawyers sought treatment under Oklahoma's Youthful Offender Act, a system intended for teenagers accused of serious offences who may still benefit from rehabilitation. The youthful offender system sits between juvenile and adult court. In Butler's case, that meant the possibility of decades in prison remained over him, but only while the court still had jurisdiction. On August 25, 2025, Butler entered no contest pleas to all 11 counts as a youthful offender. The court later approved a rehabilitation plan supervised by Oklahoma's Office of Juvenile Affairs. The conditions reportedly included 150 hours of community service, sex offender treatment, counselling, a curfew, daily check-ins, restrictions on social media, and exclusion from school property and events. He did not serve time in jail or prison. For Butler's supporters, the plan represented the purpose of youthful offender law. He was a teenager at the time of the alleged crimes. His brain and judgment were still developing. A structured treatment plan might reduce the chance of future harm more effectively than placing him in an adult prison. For the victims and their families, that explanation sounded detached from the violence they had described. Community service and counselling did not feel proportional to rape, coercion, or strangulation. One victim's parents later spoke publicly about how the case had changed their daughter. They said she completed school online, withdrew from ordinary teenage life, and struggled to trust relationships. Her mother described Butler as her daughter's first experience with love, then added a sentence that became closely associated with the case. Love shouldn't hurt. The family's attorney, Rachel Bussett, argued that the justice system had focused more heavily on Butler's future than on the future taken from the survivor. She did not insist that teenagers could never be rehabilitated. She argued that rehabilitation without meaningful confinement, accountability, or an admission of guilt did not match the conduct described in the evidence. The controversy intensified because the victims' families said they had opposed youthful offender treatment. One family claimed it believed prosecutors would maintain the adult case. Then, according to their attorney, they received only minutes of notice before the plea proceeded. The victim allegedly did not have a meaningful opportunity to be interviewed for the pre-sentence report, submit a complete impact statement, or address the court before the agreement became final. That argument became the foundation of a challenge under Oklahoma's version of Marsy's law. Oklahoma's constitution gives crime victims several enforceable rights. They include reasonable and timely notice of court proceedings, the right to confer with prosecutors, the right to be present, and the right to be heard during proceedings involving a plea, sentencing, release, or disposition. Victims may assert those rights through their own attorneys. But the Constitution also states that those rights do not transform the victim into the prosecutor. The district attorney still represents the state and retains authority over charging and plea decisions. That distinction became crucial. The victims had a right to consultation and participation. They did not necessarily have a legal veto over the agreement. Bussett filed a motion asking the court to vacate the plea, or at least reopen the proceedings so the victim could be heard properly. The motion argued that the deal had been processed in violation of both victims' rights and Oklahoma's youthful offender laws. One argument focused on what critics called the state's straight-to-adult court provisions for serious sexual offences. The claim was that prosecutors had originally placed Butler in adult court and should not have been able to shift him back into youthful offender treatment in the manner used. The district attorney's office disputed that interpretation. The former district attorney, Laura Thomas, also challenged the claim that the families had been blindsided. Her office said prosecutors had consulted both victims' families repeatedly, discussed weaknesses in the available evidence, and warned them early that youthful offender treatment was a likely outcome. The state emphasized several facts. Butler and both complainants were teenagers. The allegations arose from consecutive dating relationships. Some incidents were reported only after the relationships ended, and the state expected the defense to challenge consent, credibility, and the meaning of communications between the teenagers. None of those facts proves the allegations were false. Common in sexual and domestic violence cases, especially when the accused is a dating partner. But prosecutors are required to consider what they can prove, not only what they believe may have happened. The district attorney's position was that the plea guaranteed supervision and treatment, while an adult trial carried uncertainty. That is one of the most difficult realities of sexual assault prosecution. A case may involve serious allegations, trauma, and evidence that appears powerful outside court. But prosecutors must also predict what 12 jurors will do with intimate messages, relationship history, delayed reports, conflicting memories, and offense claims of consent. A plea deal may guarantee some accountability. It may also feel like the system negotiated away the gravity of the harm. Both can be true. Butler's defense has maintained that the public has heard a distorted version of the case. His attorneys have argued that some evidence supports consent, including a recording connected to a strangulation allegation. The victim's attorney strongly disputes that interpretation, saying the footage shows Butler strangling one girl until she became unconscious. That disagreement illustrates why the no contest plea leaves the public record unsettled. There was no full trial. The evidence was never presented from beginning to end before a jury. The girls were not cross-examined in open court. Butler did not testify. And jurors never decided which version they believed. Public anger grew rapidly. Protesters gathered outside the Payne County Courthouse. Some accused the judge and district attorney of protecting a well-connected local family. Butler's father had worked in football operations at Oklahoma State University, a connection critics repeatedly mentioned. No reliable evidence has established that the plea resulted from corruption or university influence. Suspicion grew from the leniency of the outcome, not from proof that anyone secretly intervened. This distinction matters. A controversial legal decision is not automatically a corrupt one, but the appearance of unequal treatment can still damage public trust, especially in a community where influential institutions and personal networks overlap. The controversy also reached the Oklahoma legislature. In 2026, a bill was introduced to prohibit youthful offender certification for people charged with certain sexual offences. The proposal did not change Butler's case retroactively, but it showed that lawmakers saw a potential gap in existing law. The bill's premise was simple. Some offences may be so serious that rehabilitation should occur only after adult accountability, not instead of it. Critics of that approach warn against writing laws around one notorious case. Teenagers differ enormously in maturity, danger, background, and capacity for change. Automatic adult punishment removes the ability to examine the individual. Supporters respond that rape and strangulation are already individualized acts, and that survivors should not bear the risk of an experiment in rehabilitation. While the victim's challenge moved through court, time continued moving too. Under Butler's rehabilitation plan, the court's jurisdiction lasted only until his 19th birthday. That date became a legal cliff. If he violated the plan before then, the suspended adult sentence could potentially be activated. Once supervision ended, the state's options narrowed dramatically. Butler completed the required community service and treatment conditions. In early August 2026, the court discharged him from supervision as he turned 19. The final hearing produced another burst of anger. Butler's defense reportedly argued that the case had been misrepresented and suggested evidence supported his innocence. The newly elected district attorney, Jeremiah Gregory, responded publicly. He called the defense's assertions inappropriate and misleading, said they had made his blood boil, and emphasized that the survivor's allegations should not be dismissed. But Gregory also acknowledged the legal boundary facing him. Oklahoma could not simply prosecute Butler again. The Constitution protects defendants against double jeopardy. meaning the state cannot repeatedly try or punish someone for the same offences after a final resolution. Gregory said he would submit the matter for possible federal review. That does not mean federal charges will follow. Federal prosecutors need an independent federal offence, jurisdiction, and sufficient evidence. They cannot act merely because the state outcome was unpopular. Butler's attorneys have also indicated they may seek to have the record cleared. Whether that succeeds depends on Oklahoma's laws governing youthful offender records, the precise court disposition, and any continuing litigation. For the survivors, that possibility adds another layer of pain. They fear the legal record may fade, while the personal consequences remain permanent. So, did the justice system fail? The answer depends partly on what justice is supposed to accomplish. If justice means rehabilitation, Butler completed a structured program, remained under restrictions, and avoided adult incarceration during a critical developmental period. If justice means punishment proportional to harm, the result appears strikingly light. If justice means giving victims a meaningful voice, the court had to determine whether consultation occurred, not merely whether the families agreed with the outcome. And if justice means establishing public truth, the no contest plea left that truth incomplete. There is a danger in discussing the case only through Butler's sentence. The girls become evidence supporting an argument about juvenile law. Their experiences become numbers. 11 counts, 78 years, 150 community service hours. But sexual violence does not end when the court file closes. The survivors continue living with fear, medical consequences, lost friendships, changed schooling, and the knowledge that their private pain became a public debate. The justice system's timetable ended at Butler's 19th birthday. Trauma does not have the same deadline. The Jesse Butler case did not end with a dramatic verdict. There was no jury announcing guilty or not guilty, no prison gates closing, no single courtroom moment that felt like resolution. Instead, the case ended quietly when a calendar reached his 19th birthday. For Butler, that date marked the end of supervision. For the survivors, it marked something else. The moment the justice system said there was nothing more it could do. And perhaps that is why the outrage has lasted. Not because people reject rehabilitation, but because rehabilitation appeared to become the entire sentence, while the suffering of two girls was treated as something the system could acknowledge, then schedule around. Because sometimes, the most disturbing outcome is not when the law is broken. It is when the law works exactly as written, and still leaves almost everyone believing justice never arrived. I heard that Jesse is now going to a university, and people online are raging over it, asking the university to release the information, especially to the female students, and wondering how the university can accept such individual. What do you think? Thanks for joining me tonight. Don't forget to subscribe so you won't miss any updates about this case. Until next time, stay curious, stay safe, and I'll see you on the next episode of the podcast You Can't Unhear.